a couple of steps. First is I'll give you a very brief summary of the effect of that case, Allen. Then I want to speak a little bit about the history of discovery, the history of disclosure. Certainly not in any depth, but in order to give a perspective against which you can decide for yourselves the significance of the legislative changes that have taken place in Queensland over the last 15 years or so. And then I'll turn to the case itself for what it decided. Allen decided that the statement of a doctor given to a solicitor in circumstances in which it would otherwise be privileged must be produced pursuant to the Act. The effect of this is, absent exceptional circumstances, the document is otherwise the subject of legal professional privilege. Nevertheless, if it's a witness statement by a doctor who is a witness to an event, and that doctor is not a retained expert, or it might be a nurse, not a doctor, and the statement is given to the solicitor to assist in the preparation of the case, it must be produced. I'll deal briefly now with the historical context, because rather than reacting to a decision like Allen and how their honours interpreted a particular provision of the Personal Injuries Proceedings Act, we have to make a judgment about the significance of that decision in the context of the times in which we live and the view of litigation as it is currently practiced. There's no point living in the old days. So it begins, of course, before 1854, when discovery, as a process of the compulsory extraction of documents to assist in the preparation of a case, was limited to courts of chancery, which were courts that, as all of you know, developed very many novel procedures to aid in getting at the truth. And one of those procedures was to permit a plaintiff to extract relevant documents from a defendant and to deliver written interrogatories for answer by that defendant in order to obtain the best information, not for the plaintiff, but for the benefit of the court. In 1854, an act was passed which allowed common law courts to order discovery and the delivery of interrogatories. And then in 1873, the courts were amalgamated. And that was important because whereas before the rules relating to disclosure were judge-made rules in the sense that they were common law. I mean that in the sense that case by case, they developed case by case. But in 1873, when the courts were amalgamated in England so that equity and common law principles were to be applied by the one court, the High Court of Justice, the disclosure rules became the subject of statute. By statute, I mean the rules of court. And all of us here, I think, have grown up, well, of course, all of us have grown up during a period when you ask what is your duty in relation to disclosure, the first place he goes to the statute, not to the common law. You might go to cases which interpret the statute, but that's a different thing. Now, the Chancery practice was, as you can imagine, the practice 150 or more years ago was very technical, very black letter law, and there were technical grounds to insist upon documents being disclosed and technical grounds upon which you could object to documents being disclosed. One of these grounds, for example, unknown to us today, but known to us when I started in practice in '78, was you didn't have to disclose a document that related solely to your own case. You only had to disclose documents that were relevant to the plaintiff establishing his or her case. All of that's been swept away long ago. The purpose of discovery has always been the same in the Chancery rules and then in the rules of court made in England and here. It's to provide the parties, and therefore the court, with relevant documents to assist in the preparation of the case and to assist in an understanding of the case so that decisions to settle or not to settle can be made upon solid information. It reduces surprise. It puts the parties on an equal footing in relation to information contained in documents. And of course, it's axiomatic that the earlier information is shared, the earlier an appraisal of prospects can be undertaken, and that can save time, money and embarrassment. And it helps the courts too, because it saves precious court time. So we come to almost the present day, to the 1990s, and at that point all actions in the Supreme Court and the District Court proceeded in the conventional way, with the exchange of pleadings, exchange of lists, affidavits of documents, production of documents in due course, and so on. The orthodox procedure, which didn't cater particularly for any category of case. They were all dealt with in the same way. By the 1990s, by the mid-1990s, a period I can remember well because I happened to be president of the Bar Association for 2 years, right in the middle, the insurers and workers' compensation and the nominal defendant had become extremely worried about the claims, the claims and the size of claims being made upon their respective funds. And leaving aside any other factors, one of the factors which was obvious, at least to them, was that cases were running too long until settlement and were settling on the day of trial. I can remember in the early 80s, indeed in the 80s, counsel who were specialists in personal injuries cases, having the leaders of the day, not just the silks, but the leading juniors of the day, having 3 or 4 briefs for the same day, and dumping 2 or 3, whichever one didn't settle, and keeping the one that was, for personal reasons, the most attractive one to keep for that particular counsel. You can immediately see a couple of things out of that. It must be unethical to do that, and we need to develop that any further. And secondly, it's the most expensive way for the people who have to pay the insurers, statutory insurers and the other insurers. So that was an obvious evil, and the insurers didn't like it, so they agitated for it, and in due course got the government to introduce a bill, and in due course Parliament passed the various statutes which changed the practice of surrounding litigation entirely from the way it had been in the former orthodox way. The Act we're dealing with today, the Personal Injuries Proceeding Act, is one of the results of that kind of agitation. Its effect was in many ways to shift the obligation. Of course, its primary effect was to require early disclosure of documents and other matters, but it also shifted from the position which obtained before, where people had to disclose documents, not evidence, documents, not information. If you had a piece of paper or an electronic record containing words, and the information communicated by those words happened to be relevant to the case, and they were contemporaneous documents, that is, they surrounded the event that we're suing about, then it's the document that has to be produced. You never had to produce information for asking, except by way of interrogatories, which is a very limited field that we needn't talk about today. The statutes that we're speaking about, but this one in particular, changed that so that in an attempt to get people to settle early, if that was possible, not only did you have to disclose documents, but by the means provided by the statute, you also had to disclose information. The claim form, and what we had to put into the claim form in matters of that kind, are the obvious categories. In up until the 90s, the formal orthodox test for disclosure was a very wide one. It required a document to be disclosed if it was relevant to any of the issues in the proceedings, and relevance was a wide concept, so that if a document would put the other party on a train of inquiry that might elicit other information or documents, then that document was disclosable. Now, a funny thing happened on the way to the court, because at the same time as we're speaking about in the mid-90s, when the insurers and the government and others were moving to open up the scope of what has to be disclosed and to bring it as early into the time frame of the proceedings as possible, the very opposite was happening next door, where other colleagues of ours were practicing. I'm referring to commercial litigation. Commercial litigation in Queensland, in Brisbane, of course existed forever, but as a strong component of the legal profession. It owes its existence to some pioneers in the late 60s, and then to some young people who went into solicitors' firms in the early to mid-70s, and some of their colleagues who went to the bar. And after that point, I mean people like John Dowsett and John Byrne and Paul DeJersey and people like that, Richard Chesterman, and solicitors like Brian Ernst and Ray Lingwall and Brian Bartley, Ross Perritt and others, who, unlike their predecessors, and perhaps this is a reason for it, unlike their predecessors who might have done their, as solicitors, might have gained their entry through the tradesman's back door, the apprenticeship 5-year articles, which didn't involve any tough or rigorous intellectual training. These people who became solicitors had the same rigorous education that, until then, only barristers used to get. The consequence, whatever the reason for it, was that commercial litigation really took off in the late 70s, and in the boom of the 80s, before the 87 crash, it was huge. That also coincided with the availability of good photocopiers, fast photocopiers, and faxes, and therefore the creation of many more documents and copies of documents by clients and by solicitors. And as commercial litigators, and I was one of them, we wanted to get our hands on all the documents we could. And I think everybody in this room feels the same way. If you're presented with a proceeding, you want to get everything you can from the other side. And if you shower me with things that are prima facie irrelevant, I won't complain too much, because I'd rather err on that side than miss something. So as commercial litigators, we got our usual orders in the course of business, and the result was many, many volumes, arch-lever folders of documents and briefs to barristers, little fold-over affairs, and became the multi-volume briefs that we continue to get today. But the result upon the court, there were no insurers or governments interested in any of this. The result upon the court was the court believing, maybe wrongly, that too many people were making too much money unnecessarily out of disclosure and irritating the court with applications for further disclosure. The result in the court was twofold. The first is, in the latest change of rules, the scope for disclosure was tightened from relevant to directly relevant, and so the old cases no longer apply, and that was done distinctly to reduce the number of documents that should be disclosable. And the second thing that was done was that slowly, judges would invite the parties either to delay any disclosure until much later, or only order limited disclosure. So you can see that for different reasons, modern practice raised two different pathways of thought concerning what should be in disclosure. In the commercial field, the judges would rather that you didn't have any if it was up to them, and we want everything. In the personal injuries field, there was a push for as much as possible, as early as possible. Mind you, in the ordinary case, there isn't much, but there may be a lot of information. And so in the personal injuries field, we're speaking about more about information rather than documents themselves. The reasons are different in each case and lead to the different consequences. One of the differences is that whereas in commercial litigation, the old-fashioned sense of adversarial conflict remains, and there's common ground in the courtrooms between bench and bar and solicitors that we are adversaries. We're bound to cooperate as officers of the court, not to mess things around and to narrow the issues, but otherwise we're complete adversaries, and nobody expects us to be anything else. In the personal injuries field, the push largely from the insurers, I suspect, and for good reason, was to remove the adversarial context as much as possible until the last minute. So until you reach the stage when the case is not going to settle and you're going to have a trial, and you've, by that stage, identified the issues that remain controversial, and the issues should be largely ones of legal significance upon a common ground of facts rather than an inquiry into facts themselves. Of course, there are gradations of that in relation to what happened in a particular medical procedure and matters of that kind. But the aim is to ensure that in the first stage, although we in this room might not have been conscious of this requirement that we change our approach, the requirement was indeed that we stop behaving like adversaries and begin behaving like professionals whose primary duty is to undertake an operation to see if the matter can be disposed of, resolved, fairly. And fairly means upon an equal sharing of information for the right amount, professionally assessed in those circumstances, which solicitors can do, barristers can do, a mediator can do, or a judge can do. Now, that is a huge change in the approach that we've been obliged to adopt in personal injuries litigation. And so we come to Alan's case, where if we approach it in the style of old common law litigators who are entirely adversaries, it's a shocking decision. It requires the solicitor who in good faith obtained a statement from a witness to the operation, who happens to be a doctor or a nurse, and as a consequence of which the document that's produced can be called fairly a report and a medical report, must produce that to the other side. In the sense that we adopt as adversaries, that's a very painful outcome. But in the sense that we're obliged to act as professionals working towards a just resolution and disposal of one claim for compensation, and indeed many claims for compensation as efficiently as possible, so that over the whole range of claims that are made in a year or in a decade, as few people as possible have to unjustly wait for their money or spend money that shouldn't be spent, insurers and plaintiffs both. In that context, obtaining the information which was contained in the documents obtained by that solicitor on behalf of the hospital that the State of Queensland owned and operated doesn't sound like such an outrageous thing. Justice Pincus, in a case that's referred to in Allen, in the Reasons of Justice White, said that the shift in requirement was one where now you have to put the cards on the table early, and he said they have to be face up. Now, if you accept that, you don't have to like it, and we can have differences of opinion about policy, but if we accept that that's actually how it is, subject to changing the law, then Allen's not such a shocking case, although I wish I'd won it, because I don't think it's right. But, as in many cases of statutory interpretation, where an answer can go this way or that way, whichever way it goes, people will adapt themselves to that position, and life will go on and cases will be determined. Now, let me turn to Allen itself. A little boy was ill and had a procedure performed upon him at Prince Charles Hospital when he was 16 months old, and it went wrong and he suffered brain damage. So that's the claim. Minter Ellison, who acted for the hospital, got the medical records from the hospital, such as they were, and apparently they didn't contain a great deal that would shed light upon what actually happened in the operation. So the question arose, what's the best way, the cheapest and quickest way to obtain witness statements and get some data? And what was proposed was that the solicitor would craft a set of questions, a questionnaire, and these would be given to anybody in the hospital who might know something about what happened. And that would then be given to the hospital, and somebody in the hospital would look at the questionnaire, amend it, change it, add to it, and then give it to various people. That was done. And in due course, a couple of doctors filled in the questionnaires and supplied them to the solicitors who had them. The plaintiff asked for them as relevant and disclosable, and the defendant refused to provide them on the grounds that they were privileged, and nothing in the Act obliged the defendant to disclose them. Now we come to the statutory provisions. Section 9, capital A1 of the Act says that it applies to a claim based on a medical incident. This was. A claimant, this child's next friend, has to give an initial notice of claim. That's the first pre-litigation step, and that was done. Then the respondent has to give a written response advising whether any documents are held, and copies of all documents held by the respondent about the medical services. That, of course, is subject to legal professional privilege. One of the obligations of the claimant is to provide a written report from a medical specialist commenting upon the procedures and whether there was a failure to meet an appropriate standard of proof. And of course, if you didn't get all the information, the specialist you retain would be handicapped to that extent in providing a reliable opinion. And to the same degree, the more information you get, the better the opinion. And remember, the context in which we're working is a context in which the policy has been established that the more information, the better, the faster the exchange of information, the better, the sooner the judgments are made about the case, the better. Section 30 of the Act, however, had this to say about legal professional privilege. A party is not obliged to disclose information or documentary material if the documentary material is protected by legal professional privilege. Well, thank God for that. And let's just pause there, because although the extreme old-fashioned approach to litigation is we're all adversaries and we show nothing, and the modern approach in personal injuries litigation is you exchange everything, it is a fundamental belief in our system of the administration of justice that it's a good idea to let clients and witnesses be perfectly candid with a solicitor advising a client, because that actually helps early resolution and obtaining of information. And to put a witness in that position in fear that the witness's words will be prematurely or unnecessarily disclosed to others, to put a client into that position once more is, it's believed, I think we all would accept it here, would be retrograde because it would prevent solicitors being able to give advice upon true facts. We can argue about that, but I think the better view is all one way. Hence, even in a system like that established by the personal injury statutes that have been enacted, legal professional privilege continues to operate, because if you want efficient, truthful results, you also need legal professional privilege. Disclosure is not everything, but legal professional privilege is preserved, but degraded to a certain extent. And relevantly, this, however, says subsection 2 of section 30, investigative reports, medical reports, and reports relevant to the claimant's rehabilitation must be disclosed, even though otherwise protected by legal professional privilege. But they may be disclosed with the omission of passages consisting only of statements of opinion. Now let's just look at that. That's the provision that the case was all about. 3 categories of documents: investigative reports, medical reports, and reports relevant to the claimant's rehabilitation must be disclosed. they must be disclosed even though they're protected by legal, they would have been protected by legal professional privilege by that provision. But you can redact the opinions contained in those documents. Now, that suggests that you need to disclose these documents because they may contain facts. When you get an investigator's report, you're going to tell the investigator some facts, and you're also going to ask the investigator to find some facts, and to the extent that there are facts, so the policy would have it, we should be exchanging those facts early and make sure that everybody's approaching the determination of their position with equal command of the facts. But opinions, well, that's adversarial litigation, and so you don't need to disclose it under this provision. Of course, when you come to the rules of court, when litigation commences, it's another matter. We needn't deal with that. So that's the provision, Section 30. Although you have to reveal the documents in your possession, you don't have to reveal them if they're privileged, but you do have to reveal them even if they're privileged, if the documents fall within these three categories: investigative reports, medical reports, and reports relevant to the claimant's rehabilitation. The case came before Justice Applegarth in Chambers, and he decided that the forms filled in by the doctors, and there are only two of them in dispute by this stage, were investigative reports, and so he ordered their production. Our side appealed, and on appeal we had one argument that these were not investigative reports, and I'll come to that in a minute. The other side, each side got senior counsel to appear in the appeal, so I came in for the first time in the Court of Appeal. And on the other side, David North SC, now Justice North in Townsville, he was appointed this year, appeared for the plaintiff. And we appealed, and the ground of appeal was that the judge was wrong in concluding that the documents constituted investigative reports. North puts into his outline two things. One is that, yes, they were investigative reports, Justice Applegarth was right. And then he floats, he doesn't have any confidence in it, but he floats that they're medical reports. So in we go, and the court was Justice Fraser, Justice White, and Justice Freiberg. And I'm having a hard time convincing them that these documents are not investigative reports. Because if you look at it with a literalist's eye, just coming to it like a Martian would, you would say, well, first, is it a report? Well, it is. In many respects, it's a report, as commonly understood. And Justice Fraser and Justice Freiberg recited the Oxford Dictionary meaning of report, and a report's a term of very wide import, and undoubtedly a document prepared by a doctor in response to a questionnaire is, in a sense, a report. Is it an investigative report? Well, in a sense it is, because it's a document prepared as part of a process of investigating the nature of the claim, a process that was initiated by the solicitor in the usual way that solicitors act in cases. And as she investigated the matter, she requested through the hospital that a document that we can accept as a report should be produced and furnished to her. And so in that sense it's an investigative report. That's what appealed to Justice Applegarth, and that's why he decided that the document fell within that exception to the preservation of the rule protecting privileged documents, and ordered that it be produced. I succeeded on that in persuading all three of them that the document was not an investigative report, because an investigative report is the report of an investigator. And when we speak of investigative reports, although a Martian coming to read those words and using the dictionary could conclude that the character of a document would answer that description if it was a statement by a doctor made in those circumstances. But in truth, that's not what we're speaking about in the context of a statute and against the background of the knowledge of what solicitors do in litigation and in dealing with claims. An investigative report, like a loss assessor's report or a police, Now, here's the part that's a little bit painful for me. Justice Fraser, a noble judge who agreed with all of my submissions, said this: in oral argument, senior counsel for the respondent, the other side, submitted that the documents were medical reports, but the submission was only faintly pressed and it was not developed by argument. I accept the appellant's submission that the mere fact that a doctor is the source of the information in a report about a medical incident is insufficient to constitute it as a medical report within the meaning of that term in section 32. And then he goes on to develop why he thinks that by reference to other provisions. To me, I can see why David North didn't press it very hard, because he devoted most of his career to personal injury work, and he really knew this field, and he would have appreciated, as two of the judges with respect didn't, that when in this field we have this trilogy, these three categories of documents: investigative report, medical report, and reports relevant to the claimant's rehabilitation. Those things have, those three categories of documents have two things in common. One is that they are reports, a document, and that answers a description of report, however wide that might be. But the second is, if we speak about two of them first, put aside medical reports because that's the controversial one, investigative reports and reports relevant to the claimant's rehabilitation in this field are reports commissioned from third parties to investigate and to advise upon matters within that subject. Investigation about liability or the incident, and rehabilitation report, obviously. These are documents that are not created by people who were there and provide witness statements. These are reports in the sense that we use that term in the personal injuries field. You get a doctor's report, you retain an expert. You get an investigator's report, you retain a private investigator or a loss assessor or something of that kind. So when we speak of medical reports, why should that include witness statements from persons involved in the incident given to a solicitor, rather than also be restricted in precisely the same way? Anyway, I don't know what was in David North's mind because I never asked him, and I don't care about it now, so I won't ask him. But Justice Fraser agreed that the documents we were talking about were not medical reports. Justices White and Freiberg thought they were. They agreed with me that the documents were not investigative reports. So at least I won that, but I lost on the footing that it really doesn't matter if the document is a report, and if the legislature is here abrogating legal professional privilege, getting rid of it, then there's no reason to exclude the sort of document we're talking about here from the category of medical reports. So that was the case. It's annoying to lose on a ground that wasn't argued below and was faintly pressed. But that doesn't matter, that's just personal gripes. If we come back to where we stand in all of this, it means that whereas in the course of preparing any other personal injuries case other than one involving a medical incident, subject to well-known exceptions to the operation of legal professional privilege, witness statements, even obtained by means of a questionnaire, are going to be privileged from production. In due course, you're going to have to cough up some information because nobody's going to settle with you if you don't, or at least at a trial. So it's a question of delay. But if you happen to be acting in a case where a medical incident is involved, then it is highly possible that the statement you get from a nurse or a doctor who was there at the time will be disclosed. But subject to one thing, which I'll raise with you, but I can't answer because I don't understand it. Justice Freiberg said this in paragraph 97. I had submitted that it would be an odd thing for the legislature to have chosen to remove professional privilege from medical witness statements by the doctors and nurses involved in the incident. Only in medical cases, but not to have done it anywhere. They could have done it everywhere in accordance with the policy that we spoke about. They might have conflicted with the overarching policy which informs the existence of legal professional privilege, but they didn't do it. Why would they do it here? Justice Freiberg put my submission this way. The Solicitor General submitted that the question for this court was whether Section 30, subsection 2, was intended to make an exception to the general exclusion in relation to the need to produce witness statements if the defendant happened to be a medical practitioner. He said the answer could not be in the affirmative because there's nothing in the Act which singled out medical negligence cases as obliging greater disclosure than any other cases involving professions. And the judge said this about that argument. Presumably that submission used witness statement as a synonym for proof of evidence. Yeah, I did mean that. After all, a witness statement given to a loss adjuster would not attract legal professional privilege. Once that is realised, it becomes apparent that the submission misses the point. Section 30, subsection 2 applies only to reports, not to proofs of evidence. So that's the bit that I've read and reread and I can't understand. So what that means, one of you, I bet, is going to be a party to a case where that's raised. So, in summary, the field in which we practice, this field, has moved a long way from the old-fashioned views about adversarial litigation where you keep the cards close to your chest. It's a policy which informs the acts, relevant acts, all of them, which requires early disclosure and full disclosure. It requires candour. It continues to preserve legal professional privilege, subject to exceptions. One of the exceptions now is that a document that you would otherwise consider as a witness statement prepared for the purposes of the litigation by a witness or by the client would be protected by privilege given the words of the statute. The Court of Appeal says no. Well, unless the Parliament amends this statute, and it'll only do so if the government, I don't think we're going to have any big changes of acts between now and the election, but any government, unless a government is pressed for good reason to change it, they won't change it. There really wasn't any point going to the High Court about this, because if you appear on an application for special leave to appeal for the State of Queensland asking for leave to appeal, or for the nominal defendant or for some other statutory body, and you say, look, the Court of Appeal has messed up the interpretation of a Queensland Act, the answer I've had twice now, and twice is enough, is, well, change it. Why do you want us to interpret it differently? Just change it, don't waste our time. Now, a litigant can't do that, but if the State of Queensland is the one agitating the court to interpret it the other way, and from the court's point of view, an equally simple way of getting relief is to change the Act. Whether that'll happen or not, I have no idea, but that's the reason that you can see that there wouldn't have been much point in seeking leave to appeal, although otherwise I would have thought it would be a good case to get special leave and to win. Thank you.